Understanding Turkish Inheritance Law. Turkish Inheritance Law, or Turk Miras Hukuku, recognizes two types of heirdom. The first is statutory, and the second is based on the appointment of inheritors by the deceased, a voluntary option. Statutory voluntary. However, Turkish law doesn't allow a deceased to make testamentary disposition of all assets indeterminately to one party. There are untouchable shares for some inheritors, defined by Turkish law. So, who are these statutory inheritors? They are described as consanguineous heir spouse adopted children. The relatives by blood follow the principle of the parental system. This system recognizes 3 degrees of relationship. The first-degree members have unlimited capacity on inheritance. If no first-degree inheritor is living, the second degree, the parents of the deceased, can inherit. If no one is found in the second degree, the third degree, the grandparents, can inherit. The estate is divided according to the descending line. The children of the deceased are primary inheritors with equal shares. If there are no children, the parents become inheritors, splitting the assets equally. If only one parent is alive, all assets transfer to them. If both parents are absent, the assets are bequeathed to the grandparents, again shared equally. Interestingly, adulterines, or children born outside of marriage, have the same status as those born in a legitimate marriage. The living spouse's inheritance is determined by the status of other inheritors. Quarter of the assets. If there are children, the spouse gets a quarter of the assets, the children get the rest. If the spouse inherits with the deceased's parents, they get half the assets. If with the grandparents, they get 3/4. If no other relatives are present, all assets go to the living spouse. Turkish inheritance law is a complex system, but understanding its principles can help navigate the process.